The Subcommittee on Oversight and Investigations will come to order. Today's hearing is on the FDIC's targeting of refund, coffee spilling here, I apologize for that. Today's hearing is on the FDIC's targeting of refund anticipation loans. Without objection, the Chair is authorized to declare a recess of the subcommittee at any time. Without objection, all members will have 5 legislative days within which to submit extraneous materials to the Chair for inclusion in the record. Without objection, members of the full committee who are not members of this subcommittee may participate in today's hearing for the purpose of making an opening statement and questioning of our witness. The Chair now recognizes himself for 5 minutes for an opening statement. A year ago this month, the Oversight and Investigations Subcommittee hearing had testimony from the Chairman of the Federal Deposit Insurance Corporation on its role in Operation Choke Point, which is a law enforcement initiative launched by the Department of Justice to choke off legal businesses from the financial system in an effort, per they say, to combat consumer fraud. Although the FDIC has repeatedly denied that it was involved in the DOJ-named Operation Choke Point, it is clear from the investigative work of this committee and other committees that the FDIC cooperated closely with the DOJ in identifying so-called high-risk merchants and sever their ties with the financial system through its supervisory authority. Payday lenders, gun dealers, and other perfectly legal industries were targeted by the FDIC based on the corporation's own decision about which industries were favorable and which industries were unfavorable. Regrettably, we are here today to learn about a separate but no less egregious effort by the FDIC to target refund anticipation loans, or RALs, which, simply put, are loans based on anticipated federal tax refunds. A recent Inspector General report of inquiry into the FDIC's supervisory approach to refund anticipation loans reveals a troubling pattern by the FDIC officials of targeting legitimate and legal activities through abusive and unfair regulatory practices. The IG uncovered this targeting when performing its audit on the FDIC's involvement in the Operation Choke Point initiative, which was released in September of 2015. Although only an executive summary of this extensive 180-page report of inquiry is being made public, I'm concerned because the full report details actions of several FDIC employees who were also involved in the Operation Choke Point initiative. According to the Inspector General, the FDIC, quote, set in motion a series of interrelated events affecting 3 institutions that involved aggressive and unprecedented efforts to use the FDIC's supervisory and enforcement powers, circumvention of certain controls surrounding the exercise of enforcement power, damage to the morale of certain field examination staff, and high cost to the 3 impacted institutions, end quote. In an effort to cause the 3 banks it supervised to exit the RAL business, the FDIC's Washington office also used, quote, strong moral suasion, end quote, in late 2009 and early 2010. The FDIC also used its powers to inappropriately reject underwriting plans and pressure field staff to assign lower ratings in safety and soundness examinations for at least 2 of the institutions, and used unprecedented examination resources to conduct an intrusive horizontal review when one bank continued offering RALs. The Inspector General's report also found that the FDIC's legal division believed the pursuit of such enforcement remedies against the banks represented high litigation risk, but the agency proceeded anyway. All 3 banks ultimately, no surprise, exited the RAL business by April of 2012. After the FDIC Chairman Sheila Bair asked management to look into a complaint made by one of these targeted institutions, FDIC management did not accurately and fully describe the abusive behavior to Chairman Bair. This kind of behavior cannot and will not be tolerated by Congress and the American people, who expect much more from their government and their government bureaucrats. I'm concerned that the FDIC has repeatedly demonstrated a disregard for the rule of law, for the limitations of its power, and for the financial institutions that it is supposed to serve. The work of this subcommittee is an important way to hold the corporation accountable and to expose its behavior to ensure that it is kept in check. That concludes my remarks, and I'll now recognize the ranking member, the gentleman from Texas, Mr. Green, for 5 minutes.
Thank you, Mr. Chairman. I thank the witness for appearing today, and would like to note from the outset that this was not an Operation Choke Point activity. My belief is that the witness will validate this contention. While there were things that merited, in the opinion of the IG, things that merited his attention, this was not a choke point activity. This is something that occurred 5 years ago. It has been resolved, and disciplinary action has been taken. I do think that there is some currency, some merit, some value, if you will, in examining this question of safety and soundness. And I say this because this is one of the reasons why the FDIC was engaged in the process. We have loans that are anticipation loans, loans that are predicated upon a person receiving a certain amount of tax relief in terms of a refund. And unfortunately, for many of these persons, most of whom are low income, earned income tax credit folk, I'll explain that at a later time if I need to, but unfortunately, most of these loans did not materialize as expected. Perhaps most is too strong. A good many. How many is a good many? Too many. Did not materialize as expected. So the anticipated return was sometimes less than what was expected, which means then that the bank has an obligation that may or may not be fulfilled. Interesting thing about the loans has to do with how they were generated. This is not a circumstance where a person comes into the bank and talks to a loan officer in the bank to acquire a loan. These loans were generated away from the bank in the office of some third person, some third party, and they were generated by persons who were tax preparers for the most part. These persons, in a de facto sense, became the loan officer, the loan originator, the underwriter. I'm not sure it's a good practice for banks to have this kind of circumstance exist, but for our purposes today, we won't go too deeply into it. It did exist. And under these circumstances, information was acquired, but that information didn't always prove to be true, and there were occasions when the loans were not honored in the sense that they weren't repaid. So there is some safety and soundness question here. Should banks be allowed to allow others meaning persons outside of the bank, to underwrite loans that they anticipate will be covered by a tax refund, when we know that not all tax refunds as they are anticipated are fulfilled? Example, you are scheduled to get a tax refund of X number of dollars, but you have child support you haven't paid. You have other obligations that can encroach upon that refund. So you don't get the refund of X number of dollars. You get X minus some number of dollars. And as a result, we have a bank now that has a client that is required to pay this money, but it was assumed from the outset that the money would be immediately available, almost guaranteed, by way of the earned income tax credit refund that a certain person might get. So my point is this: I think that there's much to be said about the IG's report, but there's a lot to be said also about the kind of business that was being regulated and whether the safety and soundness of the banks were in question as a result of the type of business that these banks were associating themselves with. With that, Mr. Chairman, I will yield back the 2 seconds that I have.
The gentleman yields back his 2 seconds. We now want to welcome our witness, Fred Gibson. Mr. Gibson is the FDIC's acting Inspector General. Welcome. In his role, he is responsible for all facets of the Office of Inspector General's mission, which broadly is to prevent and detect waste, fraud, and abuse affecting the programs and operations of the FDIC, and to keep the chairman of the FDIC and the Congress fully informed. We thank him for his work and for being with us here today. Our witness will also, in a few moments, be recognized for 5 minutes to give an oral presentation of his testimony. Without objection, the witness's written statement will be made part of the record following his oral remarks. Once the witness has finished presenting his testimony, each member of the subcommittee will have 5 minutes within which to ask questions of our witness. Mr. Gibson, on your table, you're well aware of this. You have 3 lights. The green is go, the yellow means you have a minute left, the red means your time is up. We'll try to remain true to the lights and the time, but I have a limited panel here today, so we might show some generosity with the gavel. The microphone is sensitive. Please make sure you're speaking directly into it. And so with that, Mr. Gibson, you are recognized for 5 minutes to give a presentation of your statement.
Chairman Duffy, Ranking Member Green, and members of the committee, thank you for the invitation to speak with the Oversight and Investigation Subcommittee today regarding our report on the FDIC's supervisory treatment of refund anticipation loans, or RALs. Our work on RALs is an outgrowth of work we performed in response to an October 2014 request from 35 members of the Congress concerning the FDIC's participation in the Department of Justice's Operation Choke Point. During early stages of Operation Choke Point, the Department of Justice attached a list of businesses, referred to as a high-risk list, to subpoenas seeking information from a variety of organizations, including some financial institutions. The high-risk list, derived from an FDIC publication, was at the heart of the concerns surrounding Operation Choke Point and was the starting point for our review. In our audit, we assessed the FDIC's supervisory approach to financial institutions that conducted business with merchants on the high-risk list. We concluded that the FDIC's supervisory approach was within the broad authorities that it's granted under the FDI Act. However, the manner in which the FDIC carried out its supervisory approach was not consistent, not always consistent, with the FDIC's written policy and guidance. Payday lending, in particular, fell into this category. We also concluded that the FDIC's participation, direct participation in Operation Choke Point, was limited to a few communications from FDIC staff to DOJ employees at the time the DOJ's initiative was implemented. During the course of that audit, we began to learn of the FDIC's supervisory approach to institutions offering RALs. Broadly speaking, refund anticipation loans are products offered to individuals through tax preparers that enable individuals filing returns to obtain a portion of their refund immediately. RALs can be legally offered in most locations. Because they are short-term, high-rate loans, the FDIC considered them to have similarities to payday loans. RALs were not on the high-risk list and were not associated with DOJ's Operation Choke Point. However, we noted that the FDIC's approach to institutions offering this product appeared to be similar to those prompting the original congressional request regarding Operation Choke Point. As a result, we decided to perform additional work regarding RALs, which led to the report that we're discussing today. This report contains information relating to open banks, supervisory matters, and information that's protected under the Privacy Act, which under the law cannot be publicly disclosed at this time. I've provided as my written statement the executive summary of the report, accompanied by the executive summary of the FDIC's response in a separate letter from the board of the FDIC. I respectfully request that that written statement be included in the record, and thank you, Mr. Chairman, for indicating you would do so. In summary, our review of the FDIC's supervisory approach to RALs strongly reinforced the concerns raised in our September 2015 audit. While the number of institutions offering RALs was limited, RALs were a nationwide product, and the FDIC's supervisory approach affected both the product and all of the FDIC-regulated institutions offering it. With this report, we concluded that the FDIC's decision-making process and supervisory expectations need to be more transparent. We found that the goal to eliminate RALs as a product line and the FDIC's approach in reaching that goal was not in keeping with that transparency. Taking our two reports together, we believe that the FDIC needs to examine how the actions described in the report unfolded as they did. That they should establish more meaningful controls over the exercise of supervisory tools, certain supervisory tools. And lastly, that the FDIC should create meaningful appeal and oversight mechanisms with remedies for institutions should they be subject to abusive treatment. The FDIC should also consider how its culture played into the events which our report details. On March 11, I received a memo signed by each of the directors committing to review and consider the key issues raised in our report and to provide a status update on their efforts by June 30. Thank you for the opportunity to present our work. I'm happy to answer your questions.
Thank you, Mr. Gibson. I now recognize myself for 5 minutes for questions. Just want to be clear, in regard to the refund anticipation loans and the 3 institutions that were subject to pressure by the FDIC, were those institutions facing safety and soundness issues based on their participation in refund anticipation loans? Is it a safety and soundness issue for those banks?
The FDIC would argue that there were safety and soundness issues associated with refund anticipation loans. So from that perspective, I think the answer is yes.
And what was their argument?
I'm sorry?
What was their argument?
The argument shifted over the course of time depending upon the time that we're talking about. There were questions.
Was that because it was a work in progress? An argument in progress?
I think it was. The argument shifted from various issues surrounding the safety and soundness of the product, the manner in which the product was underwritten. The last issue that was raised, for example, was the loss of something called the debt indicator, an IRS tool that would enable institutions to have certain information about the borrowers.
Were they finding a high default rate with these loans? Was there?
No.
So to the bank's safety and soundness, did they see a real threat to the safety of the bank?
Well, I think there's an argument to be made that numbers don't lie. The fact is that the institutions never experienced a loss rate on these loans that exceeded 2%. In fact, in most years, the loss rate on the loans was significantly less than that, and that's true we looked from 2007 forward to 2011, and during that period, the loss rates were all less than 2%.
So the FDIC might try to make the argument of safety and soundness, but the facts showed something quite different. Is that fair to say?
The performance of the loans would suggest that there wasn't that much risk.
And you didn't see deceitful behavior, fraudulent behavior from these banks with the clients that they served or the customers that they served at a high rate, did you? Or
We didn't go and really examine the individual programs of the banks, to make a call on something like that. But in the course of our work, we didn't become familiar with any such problem. No.
Did the FDIC make that argument to you that there's fraud and deceit being used by the financial institutions with their customers?
I never argued that there was fraud or deceit being used, to my knowledge.
And one of my concerns is you have a product that doesn't affect the safety and soundness of the bank, arguably, and it appears that the customers who are using the products know what they're getting, understand the terms of what they're getting. And here we have the FDIC stepping in, using their judgment for the free will of the American people, which gives a lot of us concern, which is not just in this program, but also with Operation Choke Point. I think the Congress uses its moral judgment as representatives of the people. We didn't give that authority to the FDIC. In your report, Anthony Lowe, the regional director of the FDIC Chicago office, and Mark Pierce, the director of consumer protection, were mentioned, I think, in our search 300 times in the 180-page report. Obviously, if you reviewed, and you did, the choke point reports by Congress, and you were involved in that as well, these are two common names that came up in choke point as well. Can you describe Mr. Lowe's and Mr. Pierce's role in the refund anticipation loan investigation that you did?
I'm reluctant to discuss too many details for privacy concerns, but let me think about what I can say. Mr. Lowe is the regional director of the FDIC in the Chicago region. All three of the institutions offering refund anticipation loans were in the Chicago region and accordingly were supervised by an examination staff that Mr. Lowe supervises. Mr. Lowe directs that examination staff and is responsible for it. Mr. Pierce is the head of the Division of Consumer Protection at the time of these events, and as such is responsible for oversight of the consumer protection side, the compliance side, as it were, of the examination function. Both played roles in the course of this. Mr. Lowe, from the standpoint of the implementation of directions that were received from headquarters in Washington, Mr. Pierce at a higher level with respect to the policy of the FDIC concerning refund anticipation loans as well as its implementation.
And I'm almost done here, but in the refund anticipation loans, we saw Mr. Lowe and Mr. Pierce's involvement with the prior investigations with choke point. We had a chance to review the email correspondence when they were targeting, short-term lenders. Have these two been reprimanded? Do they still work for the FDIC? Have they been fired? What do you know about their employment status?
Both employees, both are still employed by the FDIC, and I cannot speak to any personnel action that may have been taken. I wouldn't know about that. And
we are not surprised by that. My time has expired. The chair now recognizes the gentleman from Missouri, Mr. Cleaver, for 5 minutes.
Thank you, Mr. Chairman. Mr. Gibson, thank you for being here. And these RALs are products that have been around now for a while. And my first question is, do you see anything inherently evil with RALs, particularly those who are issued from reputable companies?
I don't really know that I have a position on RALs per se. I mean, they seem to me to be a loan product that's being offered to people, and that's really what they boil down to.
I mean, I'm thinking about, there are some benefits. One, of course, is that the recipient of the loan, which is based on anticipated refunds, is able to get that refund not only more quickly, but it would allow them to speed up some delayed attention toward financial challenges. And so I guess I don't see them as being evil. And my other question is, my other concern is that, and that may more impact FDIC than you as the Inspector General, but that every entity providing RALs is not designed to rip them off, and so I think we may be doing a disservice if we have a conversation that would suggest that everybody who's doing it is a rip-off agent. Now, at the same time, I do agree with the recommendations that you made, that the IG made. I think those are right on target. And I don't think a reputable entity, would back away from that. I mean, I would think that all the reputable institutions doing RALs would probably, jump right on it and say that, we can do this. Better communications internally and externally, improved guidance to supervised institutions, and enhanced appeals process, which is what you have recommended. If that is cleaned up, and I don't know if this ends up in your purview, if those recommendations are taken, do you see that as the most significant step that could be taken in terms of allowing this to be something that we live with? I don't particularly like high interest rates, even though it's high interest in a short period of time. The truth of the matter is, some people do in fact need that.
So I think with respect to the recommendations that we made, the FDIC's board indicated that they would provide us with a status update by June 30th. They indicated that they would take the key issues under consideration and advise us about exactly what they were going to do in response to that. At that point in time, we'll take a look at them, and I hope that they will be, responsive to the issues that we've raised, and we can address it at that point in time.
Do you have any idea about, my concern is Uncle Willie's tax repairing preparation company. And Uncle Willie is an automobile body shop owner when he's not in tax season, and he's a good human being. But I'm just wondering how many of those kinds of things were involved in offering the rails on behalf of, let's say, small banks, community banks.
The three banks that offered the RALs had different programs under which they would take a look at the folks that were offering these things. One of the risks associated with offering these sorts of products is the risk that the person offering the product to the public isn't going to follow the law. The banks all had mitigation programs. One bank had a fairly extensive audit program that went out and looked at a very large number of the people who were offering these in order to assure that they were complying with the law. They made suggestions directly to the board of directors of that institution. And the board of directors, as I understand it, took action in order to remediate any of the issues that came up. So there was attention that was being paid by certainly that institution, to what was going on with the individual RAL offerers, the people who were offering the loans.
Yeah, I'm through. Thank you, Mr. Chairman. But there are some of the lenders who are also banks themselves, who have a subsidiary that are actually banks, and so. But I think those are all at another level. I'm sorry for running over, Mr. Chairman.
The gentleman yields back. The chair now recognizes the gentleman from Arkansas, Mr. Hill, for 5 minutes.
Thanks, Mr. Chairman. Thank you and the ranking member for this interesting hearing. Mr. Gibson, thank you for being with us today. Do you know off the top of your head when reputation risk was added into the CAMEL rating process? My guess is sometime around mid-2000s or so, but I just, if you ring a bell.
I do not know. I don't know that CAMEL's particular, that reputational risk is necessarily, it's not an individual component of CAMEL's. I'm not.
No, but it was added in in the exam manual sometime in 2000 that everything had reputation risk and that boards needed to review that, particularly in new product development areas. But you agree that banks are responsible for their own product development consistent with the laws and regulations?
Yes, sir, I do.
And, I think banks are supposed to offer products based on consumer needs, which are we see in CRA. You get extra credit in community reinvestment exams if you show survey results of your consumer base, your neighborhoods. And so from surveys or word of mouth that banks get credit for doing product innovation and trying to meet consumer needs. You've seen that, I'm sure, in your work.
Yes, we have.
And banks have obligations for consumer compliance and for fair dealing under a number of statutes. So it always concerns me when I hear these stories of a regional office or a particular examiner kind of going rogue on taking the place of the micro-prudential manager of the bank about what he or she should not do in the product development arena. And that was kind of the whole point that we were frustrated with Operation Choke Point. Because I had a lot of customers that had legitimate reasons for refund anticipation loans, like paying off a credit card after Christmas would be number one, car down payments, home improvement, tuition payments for a semester. And so when we have these sorts of activities by our regulators, we're actually contradicting, we're hypocritical. We're saying that consumers want these products like overdraft protection or prepaid cards or refund anticipation loans, and then we don't facilitate banks offering them. In fact, we, through moral suasion and other ways, defeat that, causing these consumers who want the product to migrate out to the unbanked, unregulated, or under-regulated segment. So again, that's one of my biggest frustrations in this process. Do you think it's fair to say that if banks do product innovation and their board of directors reviews that product and that they offer it and they accept the reputational risk and the financial risk with it, that generally a bank should be able to innovate based on your work at the FDIC?
Sir, I think as a general proposition that it's up to the bank to mitigate the risks that are associated with the product that it offers. I mean, as you pointed out, you know, we create laws that establish requirements that banks are obligated to follow, and we supervise for the purpose of ensuring that they're doing so in a safe and sound manner, but ultimately risk is the bank's job.
Right. So from your review of Mr. Lowe's work, is it fair to say that the Chicago regional office was off the reservation on pursuing this compared to the national policy directives from Washington?
Well, sir, I think with respect to the RALs, what our work shows is that the national policy informed what Mr. Lowe did. I think that the national policy directed how the RAL should be supervised. The bank's offering RAL should be supervised ultimately.
But what's setting that apart from any other consumer loan product? I don't understand. If we've measured loss ratio, if we're in compliance with all the lending consumer disclosure laws, and we're operating in a fair dealing manner, why is this loan, or why is this product being separated out from any other consumer credit decision to finance a car or finance a new air conditioning system for a home? I mean, why is this being singled out? It's because of somebody's idea that it's bad, isn't that right, instead of a financial?
So I really can't answer the question. And I'm sorry to say that I can't, because I can't point to something specific that says this is why we're doing this with respect to RALs. The FDIC chose not to issue any guidance or policies with respect to that particular product. Now, there is general guidance associated with kind of a type of lending here in third-party risk concerns, but there's no specific guidance on this particular product that we can turn to that answers that question.
Thank you. Thank you, Mr. Chairman.
The gentleman yields back. The chair now recognizes the ranking member, Mr. Green.
Thank you,
for
Mr.
5
Chairman.
minutes.
Thank you. Sir, I believe you will agree that the FDIC has a mandate when it comes to safety and soundness. Is this correct?
Absolutely.
And I believe that their opinion is of great value when it comes to safety and soundness.
As do I.
And you would probably also concur and agree that while you can give opinions about the process, the ultimate judge of safety and soundness is the FDIC.
I'm sorry, sir, I'm having difficulty hearing.
Okay,
over that.
while you may give an opinion about a process, the ultimate judge of safety and soundness is the FDIC.
Oh, absolutely, yes, sir.
So any opinion that you give today, and you're a wonderful person, I love you. I know your mother does. My mother loves me. But that's just your opinion. You don't have the mandate that the FDIC has. And by the way, you've not gone so far as to say that there was not a safety and soundness issue. That's a fair statement, isn't it?
Well, sir, I didn't say that there wasn't a safety and soundness issue, but what I would point out.
Well, let me just do this. I'll let my time is limited, and perhaps someone else will work with you. Let's talk about the quality of these loans. You did not give an opinion about the quality of the loans. I think you sort of indicated that you had no position on the quality in terms of whether or not these are good products or bad products in the main.
That's correct.
So, with the banks having the duty to effectively manage safety and soundness, they have to determine something with reference to quality, because the banks also have one other mandate. I think you'll agree that the banks have a duty to also have a consumer protection component. Let me strike that and make that the FDIC has this duty. The FDIC has a certain consumer protection component associated with it. Is this true?
That's true.
Okay. So you got the FDIC with the consumer protection component. They've got the safety and soundness component. They have a real concern, especially given how certain underwriting standards in 2008 created a crisis that had a domino impact across the globe. Now, this is not of that magnitude, obviously, but they still have that safety and soundness concern, and they still have to deal with consumer protection issues, which is why we have to now examine the product itself, because the FDIC has to give some value judgment about these products. And clearly, some of these RALs had annual percentage rates of as much as 500%. Some, not all, just some. Look, I agree that if you need money, you got to be able to go in and get it if you need it. But I also think that we have to have some protections for consumers, especially low-income people. It's a balancing test that we have to engage in. So with the 500%, with the underwriting being performed off campus, away from the bank, and you couple that with the opportunity for fraud, you indicated there were some systems in place, but you did not go out and evaluate each individual underwriter, did you?
Of course not.
Okay. So you really don't know. You really don't know what those individual underwriters were doing, do you? You don't know. Come on.
Personally, no, of course not.
Of course you don't. You're the IG. You didn't go out and examine them, so you don't know. I think that's a fair statement, isn't it?
It's a statement.
Okay, well, it's a fair statement. You weren't there. You don't know. You didn't examine them. If you want to find a clever way to say, I know, tell me what that clever way is.
Well, I wouldn't say that it's a clever way, but what I would point out is this. One of the institutions was to receive, based on the examination of the bank, an overall rating of 2. It's a pretty good CAMELS rating, particularly at that
Can you do this a
particular
little
point
bit
in
faster,
time.
because I have another question for you.
That's
Now,
fine. I'll be as quick as I can.
Okay.
The point I'd make is that the DCP examiners, the consumer protection examiners of the FDIC, reviewed that rating for that institution that was offering RALs, and they concurred in it. They didn't have a problem with giving it a rating.
Let's do this. I appreciate your commentary. Let's do this. Do you agree that there was not a culture at the FDIC with reference to this type of product,
I'm sorry,
there was not a culture at the FDIC. There was not a culture as it relates to what they were doing in auditing these products. There was not a culture there. Do you agree with that?
I'm not sure what you mean, sir. I'm sorry.
Well, do you agree that this was not widespread, that all of the employees were involved in some sort of conspiracy to go out and put an end to these products? Do you agree with that?
Sir, I think that this involved a decision that was made at a headquarters level and was passed down to the field to execute, and I don't think anybody else was involved in it.
So there's not a culture at the FDIC, and do you also agree that you've been working with FDIC and they are going to give you some indications as to the corrective actions that have been taken?
Yes, they will.
Okay.
I believe they will.
And finally, and I thank you for allowing me to go over, Mr. Chairman, do you also agree that this was not, N-O-T, not a part of Operation Choke Point?
Sir, Operation Choke Point was a DOJ program.
Well, I'm going
And
to...
this wasn't part of a DOJ
Okay,
program.
all right. So that's another way of saying it was, N-O-T, a part of Operation Choke Point, right?
Yes.
Okay, thank you.
The gentleman yields back the time he doesn't have. The chair now recognizes Mr. Poliquin from Maine for 5 minutes.
Thank you, Mr. Chairman. Appreciate it very much. Mr. Gibson, thank you very much for being here. I appreciate it. I'm a business owner, and before I became state treasurer of Maine a few years ago, and before serving in Congress, I was in the private sector my entire life. And you know, one of the things that absolutely gives me fits is that this big, strong arm of the federal government, and I could extend that to say state and local government also, that continues to put pressure on our employers. You know, one of the things that we parents all want are better opportunities for our kids, more jobs. We want to make sure they're healthy and safe, they get a good education. The Competitive Enterprise Institute computes that a couple of years ago, and presumably in 2015 also, the total cost to our employers in this country for federal regulations only, Mr. Gibson, not state, just federal regulations, is $1.9 trillion. $1.9 trillion on our businesses in this country. Now, our businesses, of course, pass along these costs to the folks that buy their products or their services. So we end up paying for all this overregulation. Now, overregulation is bad enough, and I bet I spend 25% of my time, Mr. Chair, 25% of my time here in Congress, being here for a year, listening to business owners or folks that represent business owners, asking one simple question: get the government off my back. I know how to make money. I'm an entrepreneur. I know how to take risk, invest my own savings, grow the economy. In doing that, I'll hire more people and I'll pay them more. That's what we want. So now comes this Operation Choke Point or something similar to it. This is alarming. Mr. Gibson, I'm guessing as an IG, you're also alarmed or you wouldn't be here. Now, we're in a free enterprise economy where if you have a legal business, you should be able to conduct that operation, that business, legally and lawfully in this country. But all of a sudden we see, Mr. Chair, a few months ago, when we had a hearing on this, that, you know, there's some list of companies that the Justice Department didn't like. Whether you sell firearms legally, or fireworks legally, or tobacco legally, or alcohol legally. Well, let's go put pressure on the FDIC. Let's put pressure on the regulators to stop these businesses by choking off their credit. And now we have a situation that I think is very concerning and takes it to another level. Now, unless I'm mistaken, Mr. Gibbs, maybe you can shed light on this. And I quote from Deputy Director of Policy at the FDIC, Marty Grunberg, who runs the FDIC, thought it was a strong document, referring to a document that was written a few years before, which is a guideline in dealing with these issues. I thought it was a strong document, but he stated that his instinct was to wait to issue a document like this until after we, i.e. the FDIC, had taken strong, specific action with one or more of our RAL lenders. He said he believes these lenders are recalcitrant and would ignore the directive. So in other words, these are the cops showing up at your door, arresting you, and then after they do that, saying, now we'll issue a guideline on what the heck the law is. Am I getting this wrong? What am I missing here? Can you imagine the behavior of the federal government that's supposed to help our citizens in this country, help our businesses, help our families live better lives with more opportunity, more freedom? And now these regulators are saying, we don't like your business, or worse, we'll put pressure on you now, we'll write the regulation after. What am I missing here, Mr. Gibson?
Sir, I believe that one of the issues that's raised by the facts that are contained in this report does relate to the transparency of the decisions that are being made by the government. I believe that the government should be able and should be willing to explain to people why it is it's doing what it's doing. And that in this particular case, that the FDIC didn't achieve that end.
Let's drill down there a minute, Mr. Gibson, if you don't mind my remaining time. We both agree, and by the way, I salute you for your work. Keep digging. Absolutely keep digging. And you operate independently within the FDIC, and I know you have that authority and that power. Do you think, and I think you just said you didn't, that they have not explained why they conducted themselves the way they did? Is that what I'm hearing?
So I think at the time there was no transparency really associated with the FDIC's reasons for taking the actions that it took.
And why do you
Yes,
think
that's what I'm
today
saying.
they have taken those actions, sir?
Pardon me?
And why do you think today they took those actions when they did? Do you have an opinion now?
The FDIC says that they believe that these products represented safety and soundness issues and consumer protection
But does
issues
that
and
justify,
were not appropriate to a
does
bank.
that justify putting pressure by regulators on bank to shut this down and then afterwards issuing guidelines?
In my view, they should have explained why it was they felt that way.
What's next? Do you see anything coming down the road? What's next? Buying a new pair of tennis shoes? Maybe they don't like the color? I mean, what's next? Thank you, Mr. Chair. Yield back my time.
The gentleman's time has expired. We are now going to go into a second round, so the gentleman from Maine will have another chance to continue his questioning or comments. With that, the chair recognizes himself for 5 minutes. I want to follow up, Mr. Gibson, on the points that were just made by Mr. Poliquin. This is stunning to me, the fact that this individual by the name of Marty Gruenberg, in essence, in an email, was saying that let's go through enforcement first, and we'll talk about guidance in our financial institution letter later. This individual, Marty Gruenberg, low-level individual at the FDIC?
No, sir.
Who is he?
Mr. Gruenberg currently is the chairman of the FDIC.
The chairman of the FDIC, aha. The chairman is the one who's saying, let's go through an enforcement measure and let's look at guidance at a later date. Did the guidance in the form of a financial institution letter of fill ever come from the FDIC?
Specifically with respect to this product, no, sir.
And so is it no wonder that the individuals involved in this report, Anthony Lowe and Mark Pierce, that they're still working for the FDIC. Frankly, they're following the directive of the chairman of the FDIC. Their boss is in up to his armpits into the report that you provided to this committee. Yes? Is Mr. Gruenberg part of this? Does Mr. Gruenberg know what was going on?
Sir, that email wasn't written by Mr. Gruenberg. It represents what someone believed that he said.
Right. Representing a comment that Mr. Gruenberg made about holding off. And Mr. Gruenberg, as the chair, said, let's enforce first, in essence, and we'll give guidance later, right?
So that's what he reportedly said.
And did they do enforcement first?
Yes.
Yes. And frankly, the guidance never came, correct? Because everybody got out of the business.
That is correct.
No wonder changes haven't been made at the FDIC, and Mr. Gruenberg was part of Operation Choke Point. And as Mr. Poliquin indicates, we're in a situation where we have a nanny state. Mother government will tell us what products are good and bad for us. I think, as Mr. Cleaver indicated, we have people who find themselves in hard times that might need to get a little money early from their tax return. They might have to get a short-term loan because the car broke down. The family pet got hit and has to go to the doctor, to the vet, and they need to get short-term money. And we're turning everyone away from an opportunity to access cash in the short term because we think we know best, or they think they know best in Washington. And if you can't turn to a bank or a short-term lender, where do you turn? You're going to turn to Uncle Vinny, not Uncle, Mr. Vinny down the street. And he's not too kind when you don't repay. This is concerning stuff. Let me ask you this. In regard to the banks that were involved in your investigation, was any pressure put on the banks with any downgrade of their CAMEL rating that you found?
Yes, sir, there was.
Could you explain that?
A downgrade of the CAMEL's rating results in increased assessments. It can result in limitations on the bank's ability to engage in certain activities. In this case, the downgrade of an institution from a 2 to a 3 basically reinforced a prohibition on that institution participating in the purchase of assets of failed institutions, which was part of their business strategy. So it's, changes in CAMEL's ratings cause significant effects on financial institutions.
And so I think I read somewhere in your report that the FDIC was concerned there might be a high litigation cost to going after these 3 banks that are referenced in the report. Is that correct?
They did.
And it's fair to say that when your CAMEL rating is reduced, due pressure is applied and people get out of the business instead of litigating. Is that fair to say?
Sir, I don't know what the reasons were that people got out of the business. We didn't speak with them. But it's possible.
It's possible. I would just note that you look at what's taking place and the fact that last year alone, 80,000 pages of new rules and regulations have come from the federal government. It's hard enough to comply with the rules that are put out that people can try to read and try to comply with, but it's even harder when you have our regulatory body of our financial industry that tries to enforce first and give guidance later. We should know what the rules are. The rules of the game should be clear. We should all be able to understand them, and we should all be able to follow them. This is frightening that we have another act by the FDIC that goes through enforcement first and guidance, if we're lucky, second. I want to thank you again, Mr. Gibson, you and your team for the hard work they put into this investigation, and I appreciate your willingness to testify before this committee. My time has expired, and I now yield to the gentleman from Missouri, Mr. Cleaver, for 5 minutes.
Thank you, Mr. Chairman. I think I sufficiently raised the issues that I needed to raise. I would like to yield the balance of my time to the ranking member.
Thank you, Mr. Cleaver. I greatly appreciate your sharing your time with me. Sir, with reference to the chairperson of the FDIC, is it true that the statements that were called to your attention, and we want to make sure that this is clear on the record, were statements that we would probably call hearsay in some circumstances? Is that a fair statement?
Sir, that's fair.
I'm sorry, say again?
That's fair.
Yeah, hearsay. Somebody heard it, they say that they heard it, and they then repeat it. That's not the most reliable evidence. In fact, it will take some sort of exception to the hearsay rule for it to be admitted in court. Of course, we bend the rules around here so that just about anything that we want to say gets heard. But I want to kind of defend his reputation because I believe him to be an honorable man, and I don't think that he had a circumstance wherein he had an outcome that he desired, and hence any means necessary to get to the outcome was the methodology employed. I just don't see the evidence of that as it relates to him. Now, let's go to what I have here as intelligence. I have here an indication that in 2006, there was a report by the FDIC's Office of Inspector General. Are you associated with that office, sir?
Yes, I was.
You were? All right. And how long were you there?
I've been there for a long time. I've been with the FDIC Office of Inspector General since the sunset of the RTC, which was 1995 or 1996.
So it's fair to say that you would be familiar with this report?
Well, I don't know if I'd be familiar with a report.
Okay,
from
the style of the
2006.
report is challenges and FDIC efforts related to predatory lending.
I'm sorry, sir. I'm not specifically familiar with the report at
Not
this time.
specific. I don't want you to have read it in its entirety, but Have you heard of such a report existing?
It doesn't surprise me that we did one at
Okay.
all.
And would it surprise you to know that the report indicates that borrowers lose more than $25 billion annually due to predatory mortgages, payday loans, lending abuses involving overdraft loans, excessive credit card debt, and tax fund loans? Would it surprise you to know that's in the report?
No.
And if this is the case, we would then focus on the refund loans, and someone would conclude that predatory lending not being a good thing, that we ought to regulate these tax refund loans. I'm not saying eliminate, but I am saying that the FDIC ought to regulate them to the extent that they don't create a part of this $25 billion in predatory mortgages and other loans as well. But it shouldn't be a part of that. Don't you agree?
Sir, I don't know if I can comment on that.
All right, I'll accept that. Sir, I think that was a fair comment. I'll accept that you won't comment on it. I'll give my editorial, my commentary, and I think that we clearly expect the FDIC to deal with predatory lending, and we ought to make sure that we deal with these refund loans. Let me give you a case in point, what we'll call a case in point. Person goes in to the tax preparer. The tax preparer says, okay, I can get you this refund, and I will charge you a certain amount of money because I'm going to help you get a refund. The tax preparer makes a mistake or two, not intentionally, and the person does not get the amount of loan refund, well, doesn't get the amount of refund that the loan is for. And as a result, these persons who make these loans, they sign agreements. And when they sign these agreements, there's language contained therein requiring them to have to pay for the amount that the loan was for, even if the refund is a lot less. You agree with this, don't you?
I think so.
Okay, I think you're thinking right. And so, given that they have to pay for that loan, and given that you've got a person who's getting this loan with an earned income tax credit, needed the money right away, now we have a person who doesn't have the loan, you've spent that money already, and you've got this obligation that was not expected. That happened in these circumstances, such that poor people, people who needed the money, found themselves having to repay loans that they didn't expect to have to pay because of mistakes that were made in tax preparation. I yield back.
The gentleman yields back. The chair now recognizes the gentleman from Arkansas, Mr. Hill, for 5 minutes.
Thank you, Cleveland.
Thank you, Mr. Chairman. Again, I think to the ranking member, I mean, the FDIC exam manuals and exam process cover all consumer lending. All consumer loans have to be in compliance with the statutes and regulations. There's just nothing per se that distinguishes these loans from another kind of consumer loan in the exam process. So that's why I've been searching for the point of why they've been singled out and why this kind of a project or the choke point project is so off the norm from the FDIC or the DOJ's process. And with that, Mr. Chairman, I yield the balance of my time to you, sir.
Thank you, Mr. Hill. I just want to be clear that, again, Mr. Gibson, the allegation wasn't being made of predatory lending, was it, in regard to your investigation?
Not that I'm aware of.
And to Mr. Green's point, this was not about the FDIC regulating these loans. They were there to eliminate these loans. Is that what you found?
Sir, what our report found was that there was a decision that was taken or a decision that was reached that FDIC supervised institutions should not be offering refund anticipation loans. So the goal was to get them out of refund anticipation loans. That's the goal.
You'd agree that's not regulating, that's eliminating, correct?
It's not regulating.
Did you have a chance to talk to Chairman Gruenberg about this?
Sir, we've talked about it, yes.
Did he know that this elimination was taking place in regard to
So I did
these
not
loans?
speak with him personally or directly about that.
Did someone on your
I
team?
don't know.
Did someone on your team speak with Mr. Grunberg?
Mr. Grunberg really had little recollection of these events, sir.
So it's my understanding that the quote that was given by the Deputy Director of Policy from the FDIC, which stated that Mr. Grunberg thought it was a strong document, meaning the fill, but stated that his instinct was to wait to issue a document like this until we had a strong, specific action with one or more of our RAL lenders, meaning he wanted to go through enforcement before regulation. Did you ask Mr. Grunberg, or your team asked Mr. Grunberg about that email?
Yes, sir, and he didn't recall
So he didn't deny it, per your recollection?
it. He didn't recall it,
So he didn't deny it?
not that I know of.
Okay. And it's also fair to say that Mr. Pierce, in an email, said, I want to see if we can achieve a resolution with Bank A that was redacted in the next month or two, then follow up with something like this in the May timeframe before institutions get going on next year's product. And you're following up with, a fill. Is that correct? That's the.
Sir, if it's quoted, I don't remember the specific language of the email, but if it's in our report, then that's exactly what the email said.
And how many people did you interview in regard to your investigation?
We interviewed 25 or 26 people with respect to this, and well over 100 in connection with the original audit we did in the choke point area.
So how high does this go? Who's making the decisions? I mean, Mr. Hill is a former banker who is obviously outraged by the actions of the FDIC. Who's in control of the FDIC? Does it go to the top? Or is there someone below Mr. Grunberg that's making these decisions, whether it's in regard to choke point or it's in regard to the current topic in regard to refund anticipation loans?
So I think with respect to refund anticipation loans, the only answer that I can give you is that the decision was made by no one, but it was made by everyone. I can't point to a specific decision maker because I can't find anything that identifies somebody. The origin of the discussion in recent times, in 2008, was an email from Chairman Bear, or a question that Chairman Bear asked about why FDIC banks should be offering these products. It seems to have just moved forward from there.
But it's obvious that Mr. Grunberg knew about the program, at least by way of some of the emails that you've discovered. So my question is Mr. Grunberg, is he a negligent leader at the FDIC, or is he complicit in all the bad behavior of the FDIC? Because it has to be one or the other. Either he's involved and complicit, or he doesn't know what the hell is going on, and someone else is running the FDIC and he's checked out.
Sir, I believe that Mr. Grunberg was generally at least aware of what was going on with respect to RALs. What I can tell you is that members of the board did receive briefings and receive information from management, and in a variety of different ways, each of the inside members of the board was engaged in these activities.
My time for Mr. Hill has expired.
You still have 5 minutes for yourself.
The chair now recognizes the gentleman from Minnesota, Mr. Ellison, for 5 minutes.
From next door to you.
I
Mr.
know,
Chairman.
my neighbor.
That's right. Well, anyway, thank you, Mr. Chairman, Ranking Member. I've long been critical of refund anticipation loans, rail loans, these short-term high-cost bank loans secured by the taxpayers' expected tax refund are often predatory and expensive. I would say always, but there might be some that aren't, and I just don't know about them. But all the ones I've ever seen have been bad. I believe in many cases they violate the Equal Credit Opportunity Act. A rail preparer will typically charge tax preparation fees, loan administration fees, and bank fees in addition to other fees that a borrower can avoid by filing directly with the IRS. And I know your report starts in 2003 when refund anticipation loans, or rails, were turning into a huge wealth-stripping problem. Professional tax preparers, as well as thousands of small independent preparers, were brokering these deals on behalf of insured financial institutions. These 7 to 14-day loans were paid by the actual IRS refund. The rail preparers were often able to offer these loans because they partnered with banks. Numerous consumer groups decried this practice and urged regulators to stop the practice. According to your report, most large banks stopped being involved with rails. JP Morgan Chase, HSBC, and Santa Barbara Bank and Trust all stopped financing rails. So I guess my question is that right? The most well-known rail preparers, H&R Block and Jackson Hewitt, stopped offering rails? Would you agree?
So I don't really know. I'm not here to talk about whether rails are good or bad products, frankly. It's the FDIC's supervisory approach to those three institutions.
All right, so, okay. So did the IRS take efforts to stop rails did the IRS take efforts to stop rails too by not allowing tax preparers from using its so-called debt indicator?
Yes, I believe they did.
Okay. And is it plausible that the FDIC could have had a legitimate supervisory concern for the safety and soundness of institutions engaged in rails?
The FDIC did have supervisory concerns with respect to the institutions offering rails. In fact, the debt indicator or the loss of the debt indicator is something that the FDIC mentions as a reason for that concern. I mean, what I would point out in that particular regard is that the debt indicator was one of 80 to 120 factors that were used by institutions in evaluating the loan that they were making.
Thank you. In looking at your report, is it true that the FDIC staff identified compliance deficiencies at the 3 small financial institutions that were offering rails?
I'm sorry, could you repeat that, sir?
So in looking at your report, is it true that the FDIC staff identified compliance deficiencies at the 3 small financial institutions that were offering rails?
I believe there were some compliance deficiencies that were identified, yes.
Okay. So, you know, I'm looking at perhaps weak electronic return origination training, a lack of rail program audit coverage, and even substantive violation of the ECOA. Does that ring a bell for you?
Sir, that could be, yeah.
Okay. So if the FDIC had already had identified previous violations with these 3 institutions on notice, that the agency was concerned about their performance in rails?
Well, sir, all I can say in that regard, again, is with respect to one institution, that institution received a CAMELS rating of 2 from the safety and soundness examiners during that same period of time. The compliance examiners reviewed that examination, weighed in on it, and they concurred in a rating of 2 for that institution. The conclusion I would draw from that is that they weren't overly concerned about the extent of those compliance violations.
Okay. Well, thank you, and that's all I have for you today.
The gentleman yields back. The chair now recognizes the gentleman from Illinois, Mr. Holgren, for 5 minutes.
Thank you, Chairman. Mr. Gibson, thank you so much for being here. Appreciate you being here to testify, and I also appreciate your office looking into what appears to look very similar to the abuse of power that was uncovered by the Operation Choke Point. I respect that the names of some of the affected institutions will and need to remain anonymous for the purposes of your report and for this investigation, but I also understand they may have been in my district, or at least in Illinois, given the role of the FDIC's Chicago Regional Director. In late 2009, the FDIC contended that Bank A had expanded its RAL program while operating under a 2009 cease and desist order. This perceived expansion prompted M. Anthony Lowe, the FDIC Chicago Regional Director since 1985, to send a letter to the institution's board of directors dated December 30th, 2009, expressing concern about the bank's RAL products and requesting a plan for discontinuing this type of lending. In separate letters, both dated February 3rd, 2010, Mr. Lowe notified the boards of the 2 remaining institutions that RALs were unacceptable for the banks and that plans should be developed for the expeditious exit of those lines of business. The FDIC OIG determined that the FDIC's letter to all 3 institutions were coordinated through the Washington office, including the then Division of Supervision and Consumer Protection and the Legal Division. And there was discussion of a global approach at the FDIC to deal with the RAL products as well. Notably, the OIG found that, and I quote, the verbiage included text from letters that had been sent to banks engaged in payday lending, end quote, as uncovered in the OIG's September 2015 audit on Operation Choke Point. The specific language is as follows, and I quote again, "We find that RALs are costly and offer limited utility for consumers as compared to traditional loan products. They also carry a high degree of risk to an institution, including third-party reputational, compliance, and legal exposures. These risks may expose the bank to individual and class actions by borrowers and local regulatory authorities. Consequently, we find RALs unacceptable for the bank." All three banks considered in this report of inquiry are located in the Chicago region. Is that correct?
They're located in the region. Yes, they're located in the region, sir.
And the Chicago Regional Director supervising these banks is Anthony Lowe. Is that correct?
Yes, sir, it is.
This is the same Anthony Lowe who was mentioned in your September 2015 Operation Choke Point audit. Is that not right?
Yes, sir, it is.
And Mr. Lowe was responsible for sending several letters to banks asking them to stop their payday lending businesses. Isn't that correct?
Mr. Lowe sent some letters, sir.
Actually, in an informal interview with the committee staff on June 2nd, 2015, Mr. Lowe indicated that there may even be a letter template floating around the FDIC's Washington office for such letters. Would that surprise you?
So I don't know whether there was or there wasn't. I don't remember seeing a template per se.
Okay. Let me move on. On December 17, 2014, FDIC Chairman Martin Gruenberg requested that the FDIC OIG conduct a fact-finding review of the actions of FDIC staff. That's in quotes, in regards to the Operation Choke Point initiative. His request was prompted by concerns raised by Congressman Luetkemeyer in a December 10, 2014 letter, which asked that the role of the 5 FDIC officials and others as appropriate be examined. The FDIC OIG addressed the roles of the 5 individuals in its audit report number AUID 15-008, dated September 2015, entitled, and I quote, "The FDIC's role in Operation Choke Point and supervisory approach to institutions that conducted business with merchants associated with high-risk activities," end quote. In that audit, the FDIC OIG committed to conduct additional work on the role of the FDIC staff with respect to the agency's supervisory approach to financial institutions that offered RALs. The FDIC's OIG's more recent report of inquiry reveals that 2 of the 5 officials referenced by the congressman, Mark Pierce, Director, Division of Depositor and Consumer Protection, and M. Anthony Lowe, Chicago Regional Director, as well as others at the agency, played key roles in forcing banks to exit the RAL's business. What was the impetus from the OIG's report of inquiry into refund anticipation loans?
Sir, as we were doing the work with respect to Operation Choke Point, we became aware of the FDIC's approach to refund anticipation loans. There were some similarities in that approach, and it struck us that there were concerns that were similar to the concerns that were raised in the letter from 35 members of Congress that triggered our original work. So we elected to continue to conduct work with respect to RALs, even though they were a product that wasn't really directly involved in the DOJ's Operation Choke Point.
Okay. Did the OIG determine any overlap in the FDIC officials involved in targeting refund anticipation loans and working with DOJ in carrying out Operation Choke Point?
No, sir, I don't believe so.
Okay, I see my time has expired. I yield back. Bounce my time. Thanks, Chairman.
The gentleman yields back. The chair now recognizes the ranking member, Mr. Green, for 5 minutes.
Thank you, Mr. Chairman. Let's talk some more about Mr. Gruenberg. These activities that occurred, did they occur prior to 2011?
Yes, some of them did.
Okay. And is it true that Mr. Gruenberg became chair in 2011, if you know?
Yes, it is.
And as a result, it would be inappropriate and misleading to imply that Mr. Gruenberg was chair when these activities took place.
Mr. Gruenberg was the vice chairman, that's correct.
He was not the chair.
No, he was not.
He was not the chair. He was there, but he was not the chair.
No, he was not.
And it seems as though we were trying to imply that as chairman, he had knowledge of these things. He was a vice chair. He was there, but he was not the chair. As a matter of fact, there was another person who was chair, who, of course, is obviously no longer there, Ms. Baer. Is that a fair statement?
That's true.
And is it also true that Mr. Gruenberg was the person who asked for the investigation?
Yes, sir, well, Mr. Gruenberg asked us to conduct investigative work. That's true.
Yes,
He most certainly
yes, it's true, it's true. It's okay to just say it's true, because it is. He is the person that caused you to come over to perform the investigation because he requested it. True?
He requested the investigation.
So that is true. Do you have a problem saying it's true, sir?
I don't have a problem
Okay, well,
saying
is it
it's
true
sir.
that he's the person who asked for the investigation?
Sir, I don't know that I accept the premise of all of your questions.
Okay, well
and
then,
that's why
did
I'm
he
being
ask for
careful
an
in
investigation?
responding. Pardon me?
Did he ask for an investigation?
He did.
And did he ask for the investigation as it related to Operation Choke Point?
He did.
And is it true that when you got there, you decided that you were going to expand the investigation into this other area, but he was the reason that you arrived because he asked for the investigation into Operation Choke Point?
Yes.
Okay, now, and by the way, you did not do an audit, you did a review.
That's correct, sir.
Okay. Now, let's go to something else. With reference to elimination versus regulation, the product still exists, doesn't it? RALs.
Insofar as I know, it does. Insofar as I know, it does. FDIC-supervised institutions don't offer it.
Yes. And they were in the business of protecting banks, but they don't protect, well, they don't have jurisdiction over many other institutions that impose this, that have the opportunity to present this product to the public. Is that a fair statement? Other institutions do this now. There are other institutions that are doing it. Banks don't.
I assume that there are.
Okay,
Yes,
FDIC
I'm not aware of the industry
Okay.
personally.
And well, you're not aware, but let's do it this way, since I have to get this answer on the record for my own purposes. You agree that this product still exists, but not with FDIC institutions?
I
Is that what
believe
you're
that's
saying?
true, yes.
Okay. So the FDIC, while it did, as my colleagues have indicated, deal with the product as it related to them, the FDIC could not eliminate this product, so there are others who are doing it. It's just that the FDIC, the entity in charge of safety and soundness, has a duty to protect consumers. This entity decided that it wasn't in the best interest of the banks to do this, and it moved to eliminate this as a product within these three institutions. Is that a fair statement?
Apparently so.
Okay. Now, final comment to you, sir, is this. Look, I appreciate your testimony here today. I really do. And after we finish, I'm going to come down and shake your hand and offer you lunch. But I do want you to know that Mr. Gruenberg is not the source of this, and I don't want you to get caught up in some sort of implication that Mr. Gruenberg was the genesis of this and that all of this was emanating from him. He was a really bad manager, because that's just not the case. He did what he could when he found out about things, the choke point circumstance, he called to your attention. And also he has taken corrective action once you have called it to his attention. He's going to be reporting to you again in June. So I'm just a person who wants to see people treated fairly, and I think Mr. Gruenberg has not been treated fairly today, and I'm going to stand up for him. I yield back.
The gentleman yields back. Hopefully he's paying for lunch when he offers that to you, Mr. Gibson. The chair now recognizes the gentleman from Maine, Mr. Poliquin, for 5 minutes.
Thank you, Mr. Chair. Thank you, Mr. Gibson, for continuing to be here. Appreciate it very much. We all know in any organization that the bad behavior of that organization starts at the top, if there is bad behavior. How long has Mr. Gruenberg been at the FDIC, sir?
Sir, he was appointed as the vice chairman of the board of directors. I'm not sure what year that was, honestly. It was a number of years before he became the chairman of the FDIC.
And how do you become a chairman of a major regulator like this in Washington? How do you become the chairman?
Sir, you're appointed by the president and
Okay, and
confirmed
how long
by
is
the
Mr.
Senate.
Gruenberg's term appointed by the president?
Pardon me?
How long is Mr. Gruenberg's term last?
Sir, I may have to get back to you on that, but I believe it's 5 years. I
Okay.
could be wrong, but.
Okay. And how long have you been at the IG at the FDIC?
Sir, I've been the acting IG at the FDIC for almost 3 years now.
Okay, so your time is overlapped with that of Mr. Grunberg, is that correct?
Yes, it is.
Okay, fine. If I'm not mistaken, Mr. Grunberg was in a position of extreme authority at the FDIC during Operation Choke Point, is that correct?
Sir, I'm not, he was either the vice chairman or the chairman.
Okay,
at the
how many
time.
chairmen?
I'm not sure what the time frame of
How many
Operation
chairmen do you have at the FDIC?
We have one.
How many vice chairmen do you have?
We have one.
Okay, so he was either the top banana or the number 2 guy, right?
That's correct.
Okay, fine. You must associate, Mr. Grunberg, professionally and maybe otherwise with other IGs in this town, embedded at other major regulators like the FDIC. You know who your counterparts are.
I know who my counterparts are,
Okay,
yes,
and
sir.
do you think that the behavior of Operation Choke Point, where Mr. Grunberg was there and was in a position of authority and did nothing to stop it when it was exposed, in their coordinated work with justice, do you find this unusual for other government agencies here in Washington?
Sir, what I would point out is that our audit found that the FDIC had minimal direct involvement with Operation Choke Point. And in fact, the FDIC's communications with DOJ at the time Operation Choke Point initiated ceased because Chairman or Vice Chairman Grunberg, I believe he may have been the chairman at the time, basically indicated that the FDIC shouldn't participate in those. Now, I can't really speak to the rest of your question. I'm not sure that I can associate that with the head of other agencies.
Do you recall the genesis of Operation Choke Point, Mr. Gibson?
Yes, sir, I think I do.
Could you tell us a little bit about it?
Operation Choke Point was a program that was initiated by the Department of Justice.
Who was the head banana at the Department of Justice at that time?
Sir, I believe Eric Holder was
Mr. Holder was the Attorney General at the time. And how long was Mr. Holder's term?
Sir, I don't know that he had a
Okay, but he was
term.
appointed by whom?
He was appointed by President Obama.
Okay, so what you're telling me is in some shape or form, it's the administration that is responsible for appointing all of these regulators, either top people or those that eventually become the top people. They've all been, this behavior with respect to Choke Point, using federal regulators to force banking regulators to choke off credit to legally operating businesses has been conducted recently over the last 7 years. Is that correct?
Sir, I believe Operation Choke Point was conducted during that time frame.
Okay, fine. Do you find, and how long have you been in this town, Mr. Gibson?
Longer than I care to admit.
Okay, that's a fair statement. Do you find that this sort of behavior has happened throughout different parts of this federal government this last 7 years? Is it unique to this period of time?
Boy. So I'm genuinely not sure how to answer that question. I don't know that I would accept the premise that things are necessarily different now than they were prior to that period of time.
Do you find in the last 7 years, Mr. Gibson, that there's been an unusual amount of activity by the federal government to put burdensome regulations on legally run businesses that we haven't seen in the past?
I honestly don't have an empirical basis on which I could make an assessment.
How could we find out that information?
That's a good question.
And who would we go to?
So I'm sure that there are studies that are done that address that.
Another study, okay.
I-
Could you cite any of those studies?
I'm sorry?
Could you cite any of those studies for our committee now?
No, I'm afraid I can't.
Where might we go to
in
find
terms
out-
of burdensome regulation, no, I'm not an expert on that subject.
Where might we go to find out if such studies existed?
Sir, I think the Congressional Research Service would be a place to start.
Okay. Thank you very much. Thank you, Mr. Chair. Yield back my time.
The gentleman's time has expired. The chair now recognizes the gentleman from Texas for 5 seconds.
Thank you, Mr. Chairman. I referenced earlier a IG report, and at this time, I'd like to place that report in the record, if there are no objections, styled Challenges and FDIC Efforts Related to Predatory Lending.
Without objection, your 5 seconds has expired as well. I'd like to thank Mr. Gibson, you and your team for your work and your testimony today. We are grateful for that. Without objection, all members will have 5 legislative days within which to submit additional written questions to the chair, which will be forwarded to the witness. I'd ask if we do have questions that you please respond to them as quickly as possible. And with that, and without further objection, this hearing is adjourned.
Thank you, sir.